CR1 is now in session.
Good morning. You may be seated. We are here on our case number 1CACV150527, Fapani versus Bratton et al. As you know, counsel, each side is allotted 20 minutes for our argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve some time, you're in charge of keeping track of your own time. The clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We record these proceedings, so if you would please, when you approach the podium, and for the appellant each time, recite your name and the name of your client into the microphone for us. We have reviewed the record in the case. We've reviewed the briefs. We've also discussed the case in our conference this morning. So with that, you may proceed.
Good morning, and may it please the court. My name is William Fischbach. I'm an attorney at the law firm of Tiffany and Bosco, and I represent the appellant in this case, Andrea Fapani. This is a case in which the plaintiff appellant, Andrea Fapani, alleged that the defendant appellee, Courtney Bratton, committed the tort of abusive process. Specifically, Fapani alleged that after a prolonged battle of land use and zoning with the county regarding a private dirt bike track on Fapani's property, Bratton made numerous complaints to the Maricopa County Sheriff's Department alleging that Fapani's use of the motorbike track, specifically his children riding their bikes on the motorbike track, violated the Maricopa County noise ordinance. The amended complaint alleges that Bratton filed these complaints for three reasons. One, to force Fapani to remove a lawful recreational facility from his property, specifically the track, which the county had said was legally permitted under the property zoning. And Bratton wanted the track removed because she considered it to be unsightly, and she believed that the removal of the track would restore value to her own property. The second reason is Bratton disliked Fapani and wanted to force him out of the neighborhood. And then finally, Bratton wanted to discourage Fapani from completing his residence on the property. As alleged in the amended complaint, the Fapani property was vacant when Fapani acquired it, and his intention was to build a private residence coupled with some recreational amenities such as a private equine facility and, in this case, a private dirt bike track. The county records indicate that Bratton made at least 8 complaints to the Sheriff's Department. We believe that there were many more not reflected in the records we were able to obtain from the Sheriff's Department. But of those complaints, 2 of them resulted in the ultimate prosecution of Fapani. The first of those complaints was served by Deputy Bolts. Well, let me back up.
Let me interrupt you if I could, counsel.
Yes, Judge.
What does the record tell us about the nature of the complaints that were made? Were they phone calls, letters, emails? What were they?
I don't know that there's any specific information, Your Honor, but they were phone calls to the Sheriff's Department.
Okay. So she called the sheriff and said, get out here and do something about this.
Multiple times, Your Honor. And it is alleged in the amended complaint that the Sheriff's Department repeatedly refused to cite Fapani for violating the noise ordinance. This is an area of Maricopa County known as Rio Verde. It is an area up in kind of northeast of Scottsdale. If you go east on Dynamite Road towards Rio Verde, that's the area we're talking about. It's an area that's highly rural. It is, in fact, zoned rural, either RU43 or RU190. As alleged in the amended complaint, this is an area where it's not uncommon to see things like private firing ranges, private horse facilities, and, as alleged in the amended complaint, private dirt bike tracks. Fapani's track was not unique in this area of Maricopa County. It's presumably the reason folks choose to move out to the Rio Verde area is because of its rural zoning designation and virtually no land use restrictions. People can do things like build private shooting facilities or private dirt bike tracks.
Counsel, it wouldn't be that unique, would it, for the sheriff's deputies or police officers to turn down requests to cite? I mean, if you look at barking dog situations, parties, domestic violence, aside from zoning violations, I mean, it's not out of the ordinary, would it be, for an officer to say, no, I'm not going to cite either party?
Of course not, Judge Thompson. I think we all know that just because the police are called.
Record, our nameplates are short.
Oh, I'm sorry.
Actually, I don't mind being Judge Thompson, but I'm actually Judge Brown.
Well, my apologies to both Judge Brown and Judge Thompson. But Judge Brown, you're quite correct. Not every call to law enforcement necessarily results in a citation. Law enforcement officers have a great deal of discretion as to whether or not to impose a citation. But based on the facts alleged in the amended complaint, it should be inferred that the sheriff's deputies were refusing to cite Fapani because there was nothing inconsistent with Fapani's dirt bike track such that it, quote, disturbed the peace and quiet of the neighborhood under the noise ordinance, because, again, this is a very common thing in Rio Verde. As alleged in the amended complaint, private dirt bike tracks are a common sight there. Rio Verde is also adjacent to the Tonto National Forest. So, as alleged in the amended complaint, it's very common to see people zipping back and forth on razors. That's like a private ATV, and dirt bikes and things like that. This is not a master plan subdivision in the middle of Chandler. This is rural Arizona, and that's what folks do out there. And you can also infer that, Judge Brown, because it is alleged in the amended complaint, and if I could, I'll direct your attention specifically to paragraph 48 of the amended complaint. When Deputy Bolts served Fapani with the initial complaint, he said, quote, I don't think you're doing anything wrong, but if I don't cite you, Bron is just going to keep calling us. And it is alleged in the amended complaint that the sheriff's department changed their attitude towards Broughton's calls because they realized that unless they went out there and they cited Fapani for doing something that Bolts even said, I don't think was wrong, Broughton would continue to consume the time and resources of the sheriff's department.
Okay, and obviously we assume the veracity of everything you're
Yes,
saying,
of course.
everything you've alleged. How does that, and to cut to the first issue, which I think sort of a initial threshold issue is, how does Mrs. Broughton's activities, everything you've alleged, how does that constitute judicial process?
Well, I'm glad you asked that because there is a case on that very issue, and it's Ledvina v. Sarasani. Now, that case was admittedly a case which involved whether or not a plaintiff could sue a complainant for defamation. And Ledvina held that there was an absolute privilege for a complainant to provide false information to law enforcement and not be subject to liability for defamation. But the court in Ledvina went out of its way to note that a complainant who provides false information in a complaint to law enforcement could still be subject to liability for either malicious prosecution or abusive process. And Ledvina also recognized that the complaint to the police, and I'm quoting Ledvina here, is, quote, the first step in the judicial process. The complaint itself is process, and one of the reasons we cited that additional authority, I believe, on Monday is to bring to the court's attention cases which specifically held that complaints to law enforcement, even if those complaints are not even acted upon, can constitute process for abusive process. And
on that case, counsel, two questions. First, are you alleging that the phone calls that led the phone calls that led to the two citations, that false statements were made to the police on those two phone calls?
There is nothing. We never.
Just to bring
we don't
tie it to Ledvina,
yeah.
the Ledvina case.
You know, consistent with our and my Rule 11 obligations, we didn't have transcripts of the phone calls where we could say, yes, she said something false. But as alleged in the amended complaint, Broughton had a history of wrapping false statements into her complaints previously to the Planning and Zoning Board. For example, she said that the land was zoned residential when it was in fact zoned rural. She said that Fapani was using the bike track for commercial use when in fact he was using it for just his children. And we do allege specifically in paragraph 40 of the amended complaint that Broughton encouraged her neighbors to make similar complaint to the Sheriff's Department by, among other things, falsely claiming that Fapani intended to use his track for commercial use. So we did have evidence that Broughton was stirring up the neighbors and getting them to call the Sheriff's Department by claiming that Fapani was going to use this track for commercial use, which was false. But I think your question gets at the underlying issue there, Judge Brown, is does it have to be a false complaint for it to be an abusive to meet the threshold for abusive process? And I would say the answer is no. I think that was the statement in Ledvina referenced a false complaint because it was a defamation case. And as we all know, defamation requires a false statement. So we have to look at that statement in the context of what Ledvina was really about. But if we were to say that there's only abusive process if the complaint to law enforcement is false, well, then you're grafting almost a probable cause element onto.
That's not part of the tort. But
exactly, Judge Johnson.
Let me bring you back to the analogy, though, or to your argument based on Ledvina. I'm not sure it makes sense. I'm not sure the dicta in that case necessarily follows. For this reason, let me throw this out. I'd be interested in hearing your response. The absolute privilege to a complainant against a defamation claim encourages or protects a citizen who makes a complaint to law enforcement under this case. What you're arguing is that same principle would lay that complainant open to liability, however, for abusive process. And so it doesn't make sense that the two necessarily, that the second necessarily follows from the first, because to say that would be working at cross principles.
Well, and but Judge Johnson, that is what the law does in fact hold. And not only is that the case in Ledvina, but it also cites to a case out of Division II called CR1, which also went out of its way to make the same statement, which was it was a case involving the same issue of it was a civil case, but that was a case where there was the complaint was it was counterclaims which asserted that the original complaint contained defamatory information, and the appellate court Division II said it doesn't matter if it was defamatory because it's absolutely privileged. But Division II went out of its way, just like the Ledvina court did, to say that anything our holding here does not affect the viability of an abusive process claim based on these same facts. So that is the state of the law, and that's why Ledvina went out of its way, I think, to put that dicta in there to make it clear that it wasn't granting absolute immunity from all torts that may result from a complaint to law enforcement. You can think about, there's obviously abusive process and malicious prosecution, but you can think of other types of mischief that a serial complainant such as Broughton could manifest by repeated frivolous complaints to law enforcement, such as tortious interference with business relations. And I think that's what Ledvina was getting at, Judge.
If Ms. Broughton was really sick and tired of the noise, how is it abuse? Let's go to the second prong. How is it a misuse of the process, assuming it was process, to call the sheriff and say, there's a violation here, shut it down?
Well, and I'm glad you asked that question because based on the allegations in the amended complaint, I think it can and must be inferred that noise wasn't the issue. If noise was the issue, Broughton would have started by filing noise complaints. But in fact, she started by filing land use complaints with Maricopa County Planning and Development Department, and then later the Maricopa County Board of Adjustment. It wasn't the noise from the track. It was the fact that Broughton hated the fact that there was this unsightly track in her neighborhood.
I wouldn't like that in my neighborhood.
Well,
What's wrong with not wanting a track?
Because, and forgive me for being presumptuous, Judge Johnson, I'm going to assume that you don't live in Rio Verde, where people have this kind of stuff out there. And I agree with you. If this was the middle of Chandler or Gilbert and master plan communities, it would be a complete non-starter. But out in Rio Verde, where it's the wild, wild west, this kind of thing flies. And that's why the sheriffs didn't want to cite Fapani, because this is the kind of thing that goes on out there. And frankly, that's why people move out to Rio Verde, because they want to take use of the big open spaces and this, frankly, lax approach to land use regulation. But your original question, Judge Johnson, is, well, why can't she complain about the noise? Or why can't we presume that these were legitimate noise complaints? And I think it must be inferred from the amended complaint that it wasn't the noise, it was the fact that he had wiped out 20 acres of pristine desert landscape and put a track there that Broughton didn't like. The track could also be used in a way, in fact, we allege in the amended complaint, Fapani went to Broughton and said, can I use this in a time of day or certain days of the week so that I don't disturb you? And Broughton refused to meet with him. So it wasn't the noise, Judge Johnson. It was the fact that she didn't like this track, and for whatever reason, Broughton did not like Fapani himself, flipping his wife and his children the bird and posting statements on the internet that he's a tax cheat and trying to harm his business. So I don't know that that's an inference you can make under these facts. I see that I'm down to about 5 minutes, so subject to any questions from the court, I'd like to reserve the final 5 minutes of my time in rebuttal.
Okay, thanks.
Good morning, Your Honors. May it please the Court. My name is Ian Quinn. I'm a sole practitioner in Phoenix, and I represent the Brattons in this matter. The core of all of our arguments on the successful motion to dismiss in our appellate brief is that the sole claim for relief, the abusive process that was pled by Fapani, was defective because you couldn't even satisfy the first of the elements of the tort. That is, did Bratton use process, judicially sanctioned process, in a way that was later misused and caused harm to Fapani? Now, let's look at what the complaint actually alleged about the use of process. You've heard a lot from the appellant about the history leading up to the complaints in the ultimate prosecution. You've read a lot about that in the briefs and in the record below. But what does the amended complaint actually say? It says simply that Bratton demanded that the charges be prosecuted and that the county attorney's office later acquiesced to that demand. Now, I'm not clear how that actually constitutes or imparts specific action on Bratton's part anyway. But even assuming that language gets us past Arizona's notice pleading rule, what does it impart to her about the use of process? Now, counsel cites exactly one Arizona case, Ledvina, to stand for the proposition that these complaints and these demands and the later acquiescence by the county attorney constitute the use of judicially sanctioned process. But the reliance on Ledvina requires two really remarkable assumptions. The first is that the Neinstedt case and its progeny so broadly define process that pre-litigation activities satisfy the requirement. But we know that's not true. Through later cases, whether you look at Crackle, Morn, Gray, and even Neinstedt itself to an extent, there is no Arizona case that stands for the proposition that pre-litigation activities of this nature that Fapani alleges can constitute the use of judicially sanctioned process. Look at what the Gray case cites from the state courts of California in determining what judicial process is. It says that it's something that's done under the authority of the court, using the court's inherent power. There isn't any allegation here that Bratton did anything that somehow subverted the county attorney beyond this simple demand. But never mind that. Get past that for a moment. She didn't file any charging papers. She didn't sign any complaints here.
Assume that she did. Let's assume, for argument, hypothetically, assume that the officer said, the sheriff said, look, I need you to initial. I want you to sign below, or right here, or attach a statement, whatever. I want you to initial this complaint. that you're agreeing to move forward with these charges, would would that constitute judicial process?
Probably not, for a couple of reasons. The first is that there's still the distinction between a complaint and charging papers. So if the question is...
Wait, I think we're, okay, let's get our words here. You mean a complaint like in the sense that I pick up the phone and call the officer saying there's a disturbance next door, would
Right.
you come check it out? That's a report. Just call it a report. You're recording. But an actual complaint is the uniform traffic citation.
Right.
In this case, right? That was based upon the documents attached to the response to the motion to dismiss?
That's my understanding, yes.
Okay, so there's the difference. What if the officer, she had actually signed the uniform traffic citation? Just hypothetically.
That could be materially different, and that leads to one of the supplemental authorities that was cited by counsel. Both Garcia and Goen both have that element where in those states, for those particular charging papers or the initiation papers of the relevant action, there was either a Rule 11 avowal where the defendant signed the papers, or there was a complaint, a form just very much like what we're dealing with here, but the complaining party had to actually sign it, avowing that this is my factual submission to the court. None of that exists in our process here.
Well, no, there is an alternate procedure in Arizona for using a long-form complaint. Doesn't have to be commenced by a traffic ticket. And in some of the rural jurisdictions like my home in Flagstaff, the city of Flagstaff historically has allowed citizens to file the long-form complaint, which clearly invokes immediate judicial process.
Oh, Judge Thompson, I fully agree with you, and I wasn't meaning to say that it's impossible for that to happen in Arizona, but in the facts of this case, it didn't.
Right.
And
I think Judge Brown's question was meant to highlight a possible distinction.
Understood, Your Honor. The second distinction, or excuse me, assumption that we're forced to assume in applying Ledvina at all is that it's on point. I mean, we're talking about dicta in a defamation case. If you read the Ledvina opinion, it doesn't cite to any authorities that are relevant in a judicial process case or an abuse process case. It doesn't cite to the relevant restatement sections, and it doesn't consider in any meaningful way what constitutes a judicially sanctioned process. Now, with all due respect to the appellant's position here, I think it's extremely difficult to shoehorn that case into the line of cases that follow from Ninth and its progeny. As I noted in my papers, the authoring opinion, the author of the Crackle opinion, sat on the Ledvina panel. And the author of the Ledvina panel sat on the Crackle opinion. These two opinions are about a year apart. And so if they wanted Ledvina to amend what they'd said in Crackle, which was a very textured discussion, talking about, look, even if you don't utilize a specific element of court process, but you weave together positions that you take in a court proceeding, that can constitute process. It's a very thoughtful opinion in my mind because it does deal with some gray areas in the case law. If those judges wanted to make the point in Ledvina that, look, never mind all of that we said in Crackle about what constitutes judicial process, it's a comment meant to sue the losing party to say, look, we understand you wanted us to take a harder line and allow you to pursue a defamation claim against a party that you feel submitted false information to law enforcement. But we will only consider that in extreme circumstances. Look at the quote that they include from the New Hampshire Supreme Court when Ledvina talks about some of the points that Judge Johnson raised about whether the policy arguments in Ledvina really support what appellant's trying to get at here. It says that there's no guarantee in our society that only guilty persons will be accused and arrested, except in extreme cases for which malicious prosecution or abusive process are adequate remedies. A person wrongfully accused of a crime must bear that risk. The question before you is whether Bratton's telephone calls complaining about a dirt bike track constitute such an extreme case that she should be subject to this abuse of process complaint. And I submit that for technical reasons, we don't even reach that point. But policy reasons also dictate that we shouldn't open up the floodgates in Arizona courts for this type of litigation. This type of interminable litigation is what Ledvina called it, which at least in this case has lasted a year and a half and has borne a heavy burden on a private citizen.
Counsel, do both parties, well, you can't speak for opposing counsel, but do you consider that Mrs. Bratton was treated as a crime victim? Was she, under the Arizona Constitution, was she a crime victim?
I think, frankly, I'm not a criminal practitioner, so I'm speculating a little bit here. But I think that had she wanted to invoke that protection, she could.
There was a page of, or it was a little bit difficult to read. There were a couple of pages attached to the response to motion to dismiss that said victim rights or something
Yes.
to that effect. That a little bit hard to read as far as who signed what. But I just wondered what your take on that was, because if we're talking about policy, and the Ledvina case obviously talks about the policy of the as Judge Johnson mentioned, the victims' rights that Arizona citizens have under the Constitution, and so that's something that seems to be or potentially at play here.
Well, and I don't disagree with you, but also, even if Bratton's simply a third party and she's not a victim, I think the policy considerations are almost more relevant. Because here we have somebody who is only doing their duty as a citizen to report something that's going on to law enforcement. Now, did Bratton have an interest in this dirt bike track? Did she have skin in the game, as it were? Of course she did. She lived near it. So she's going to be more inclined than the average citizen to report what's going on. But there isn't necessarily information on the record that tells us that Bratton reported the noise violations falsely and didn't mean to report them in such a way that they were illusory. Consider the land use complaints that she made, and counsel talked about those on his time, about how, look, she made these land use complaints first, and then when that didn't work, she resorted to the noise complaints. First of all, we're dealing with a private citizen who's not an attorney, not a law enforcement official. But also consider that any meaningful consideration of a land use code involves noise. If in terms of what you can and can't do on property, land use codes throughout the state, and presumably here, talk about activities that generate noise and whether or not that noise can be considered in allowing a use. Now, so it's not enough to say that she made a land use complaint, so she wasn't talking about noise. The use of land involves various things, including noise. And I don't think the record's clear enough below to say that her land use complaints didn't consider the noise aspect of the dirt track. I think it's clear that that was one of her concerns.
Where in the record do we find the grounds for the acquittal, the court's acquittal of Mr. Fapani?
That's been somewhat in dispute between the parties. In my motion to dismiss, I asserted that the reason that the complaint was dismissed is because the prosecutor didn't adequately establish jurisdiction,
right,
whether it was in this unincorporated area known as Rio Viejo or Scottsdale, the city of Scottsdale. And part of Rio Viejo is, in fact, in Scottsdale. And apparently they didn't have the facts or the evidence to establish that to the justice court's discretion. So, however, appellant argues that the record below isn't that clear, and he says that, and he says that, look, he was acquitted, and that should be the end of the discussion. So I don't mean to misstate the record.
Do we know? I mean, where in the record do we have anything more than just a simple one-page dismissal, right, or acquittal? There's something we saw, but it didn't.
I think we have the docket sheet.
Didn't specify the grounds.
My understanding is that there may have been a recording of the proceedings, but that's not on the record with you today.
Now back on the judicial process issue, whether your clients actually directly use judicial process, can't you be held liable for tort for causing somebody else to conduct themselves tortiously, inducing them? So then the appellant's theory would be, well, the Brattons induced somebody else to commit what would be a tort.
I think as a matter As a matter of law, I don't disagree with you. I think, and one of the arguments that appellant makes is that there's really no...
You sort of set the machine in motion.
Right. One of the arguments appellant makes is that if you accept my position that there's simply no way that there can be an abusive process claim in a criminal context. But I don't agree with that. I think it really depends on the nature of the facts before you. I mean, I think that you could specifically allege that Bratton either brought some sort of political force to bear, or tried to interplay the use of different persons to mount not just a campaign of telephone calls making the complaint, but actually trying to maneuver or manipulate the elements of either the county sheriff's office or the county attorney's office to make exactly that type of a factual argument. But I don't think this complaint does that. Again, what does the complaint say that Bratton did once she submitted the complaints? It says that she demanded that they be prosecuted and that the county attorney's office acquiesced. That's not enough of a factual record to make the type of claim that I think you were hinting at in your question, Judge. So Ledvina's dicta shows that it's perhaps a necessary but not sufficient condition for an abusive process case to accept that Ledvina provides that, hey, if you can't establish a defamation case, you can't establish an abusive process case. But the abusive process case law, and whether or not you're using an element of judicially sanctioned process, stands on its own. It's very clear in Arizona. And an appellant's asking you to take a radical departure from the 9-step cases in its progeny. And I submit that because Arizona law is clear, unless there's a compelling policy reason to so overturn that, you can't.
So what are the outer limits of judicially sanctioned process? We've talked here about a citizen signing a complaint, as is done in Flagstaff, and so is that the outer limit, or do you have to go, or do you have to be in a courtroom, courthouse to do something?
In my mind, the bright line is whether or not you are using a process that's done under the inherent authority of the court. So theoretically, and I think the Crackle case has a textured discussion of this. You can do things that are a mere refusal to settle in Crackle isn't enough to constitute abusive process, but misusing a settlement conference is. Okay. A settlement conference doesn't occur in a courtroom usually; occurs usually in a private law office. But still, that settlement conference, the reason you're there, at least in Maricopa County, is because you have to get a trial date. Yeah. So I think the outer limits are, do you not necessarily file a motion, submit a discovery request, or get a subpoena? That's clear. But do you somehow use that process in a way that's inappropriate? And I think there are cases, Crackle in particular, where maybe you justifiably had a defense, but you still misuse the process in such a way that caused damages that are compensable.
Well, you're talking about misuse. You're talking about that element. What I'm talking about is process. What's the outer limit of process?
Well, I think if you look at the Gray case, which tells us that Liz Pendens is not process, because a Liz Pendens is recorded with the recorder, not with the court. If you
may not file Liz Pendens when you have a lawsuit.
It's not mandatory.
So it's not required.
Exactly.
Counsel, that's an interesting case. It's short. It's really short. It's and it relies on a California case. I mean, not much analysis there, but yeah, I've seen where parties can do a tremendous amount of damage by recording a Liz Pendens.
And there's a statute that addresses that, 33-420.
Right. Exactly.
So it has its own statutory penalties if you do that. So
you would say, okay. I mean that's fair. That's a fair point. But still, it's not done. You file that. Isn't that part of the case? You record it with the recorder's office. Don't you file it in the case?
Well, respectfully, Gray holds otherwise, but you don't. Even though something's
file it in the case, it's got a case number.
Well, I apologize, Your Honor.
No. Go ahead.
Simply because you submit something to the court doesn't mean that document was authored and initiated pursuant to the court's authority. So I think that the gravamen here of a notice of Liz Pendens is, what is its effect? It notifies people who are looking at the chain of title what's going on with the litigation. That notice And so if we're talking about outer limits of abusive process, Gray doesn't go into a lot of detail, and there's not a lot of reported cases that do, in my mind, because that bright line is fairly clear. If it's something that's done under court procedures, under court process, then it's the use of judicially sanctioned process. If it's not, if it's done pursuant to some other authority, then it's outside that line. I only have a little bit of time left, and I'd like to reach just a couple of points, unless there are other questions. First, there's the trial court's ruling is criticized because appellant argues that the court assumed facts that weren't in the amended complaint, namely that the Maricopa County Attorney's Office exercised its sound discretion in deciding whether or not to prosecute Fapani. I would submit that it wasn't that the judge assumed facts, the judge assumed law and the operation of the criminal system. My brief has a discussion about the prosecutorial discretion and how that's simply an element of the criminal system in the United States and indeed here in Maricopa County. The judge could take judicial notice of that. And I think those comments in the complaint weren't meant to say that he was assuming specific events or facts took place. He was assuming a specific operation of the court system, which is something that he can take judicial notice of. I'd also like to note that I discussed two of the supplemental authorities, but not the third, which was Polaris, that was submitted on Monday. The Polaris case involved a defendant who physically caused commitment papers to be filed with the court. Given our discussion today, I think that type of a factual background clearly separates it from Arizona's line of cases that talk about the limits of the use of judicial process. I'm out of time. Thank you.
Thank you very much.
Just to address a couple of the points, Judge Thompson, you had inquired whether or not setting events in motion was sufficient to constitute the tort, and we do have an Arizona case, Rondelli versus Pima County, that answers that question in the affirmative, where it says that one who procures some kind of criminal process, such as an arrest warrant, can be subject to abusive process. So the requirement that Broughton put pen to paper to constitute process, I think, is not a requirement under the Rondelli case, because it recognizes that most complaints are made just verbally or via phone call to the police, and it's pretty unusual for the complainant to actually sign something like an affidavit, at least with an offense such as this one. The question about whether or not the Victim's Bill of Rights comes into play here, I think that would be taking a very extreme position, Judge Brown, to conclude that the Victim's Bill of Rights somehow eliminated the tort of abusive process against victims, because admittedly Ledvina does go into a very lengthy policy discussion there, and it does discuss the Victim's Bill of Rights, which, as we all know, is now part of the Arizona Constitution. But even Ledvina recognized that there were limits to that, and that's why it stopped short of saying that our policy here, as it applies to defamation, does not apply to abusive process and malicious prosecution. In terms of actual process, I would point out that not only did Broughton make complaints to the Sheriff's Department, but there were 2 tickets that were issued to Fapani. Those tickets are, at least in the justice court context, those are essentially the charging documents. So not only did Broughton complain to the Sheriff's Department on 2 occasions, she procured the charging documents, in this case, the 2 traffic citations that were served on Fapani. And again, they were served on Fapani. And we know that because it's alleged in the amended complaint, and it's also clear from the copies of the tickets that were attached to the response to the motion to dismiss. Service of a judicial document can constitute process, and we know that from the case of Donahoe versus Arpaio, where a subpoena was served on a very respected member of the Superior Court for the sole purpose of harassing him.
Pretty out there, aren't they? I mean, if I recall correctly, they sent the process server to serve Judge Donahoe, and this process server had previously threatened to kill.
Correct.
Judge Donahoe.
And that goes to kind of show the outrageousness of it. But the question was, what was the process? The process was the process server going out there, serving papers on Judge Donahoe, because you have to have process, Judge Brown, and that was the process, the service of those papers.
But the traffic ticket, or the ticket that was served on Mr. Fapani was not signed by Ms. Bratton.
No, it was not. But again, I think it stands for the NIDSTED, if anything, stands for the proposition that Arizona has a very liberal definition of process. We've departed from the notion that process are writs and warrants and things like that. Allstate, too, where you've got a refusal to participate in good faith at a settlement conference, that constitutes process.
I don't mean to say that the ticket is not process. What I'm wondering is whether, having not signed it, she can be held for it.
Well, I think if she procured it, if she was the determining factor in the sheriff issuing that ticket and serving it on Fapani, that is sufficient. And again, I go back to the Rendelli versus Pima County case, because it's not a question of whether or not you signed something like you're signing a pleading or a written discovery request. The question is, did you procure it? And if we require the complainant to have signed something, that almost, in most circumstances, eliminates the tort of abuse of process in the criminal context. And I think that would be taking, a rather extreme position. And there's certainly nothing in the restatement that suggests that the tort is dependent on the defendant putting pen to paper. The question is whether or not they set in event a certain or set in motion a certain chain of events. And in this case, Bratton did. She complained to the sheriffs. Fapani was cited. He was served. He was tried. And he was eventually acquitted. I would say that I am mindful of I think, the difficult issue the court is grappling with here, which is to what extent do we want to hold that people who report crimes can be subject to civil liability? And as a former prosecutor, that's something I would struggle with, too, in your position. And my response to that is this, and if I could just, I know I'm out of time, finish my point here. In the same way that our courts serve as gatekeepers for intentional infliction of emotional distress claims, I think it's highly appropriate for our courts to serve in a similar gatekeeper capacity in terms of the outrageousness or the bad faith intent behind the abuse of process. And I think that's the bulwark you have there against unjustified lawsuits against complainants or victims, as the case may be. I thank the court very much for its time and attention this morning.
Thanks to both sets of lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we stand in recess.